Yeah. All right, let's go right on to our next caller. Barbara, who do we have on the line?
Roger, we have Gabby, and she is calling for a friend of hers who is experiencing problems regarding a repetitive injury to her back and shoulders.
All right, let's talk to Gabby. Thank you, Barbara. Gabby, this is Roger Riedmiller of Laura in the Line. How can I help you?
Yes, I want to tell you thank you for having your program. There's a lot of people that need this information. My concern is a friend that has worked close to 30 years on assembly line work. She is now what I consider suffering from what is repetitious work injuries, and she has gone and reported it to her employer and completed physical therapy, was told to return back to work at full duty. During her rehabilitation, the therapist told her, because of an auto accident she had years ago, about 25 years ago, that which involved the pelvic and the thigh and stuff. She's shorter in one leg than the other, but she has the orthopedic heels to help to straighten that out. So she's never had a problem. It's never affected her work.
Okay.
She's, in fact, worked overtime, which amazed me for so many years.
Right.
Now that she's having problems, they want to focus on this heel that she's got.
I'm sorry, they want to focus on the what?
This heel insert that she has. Okay. Now, this what she's having problems with involves her neck, shoulders, and the upper back.
Okay. So what is your question?
All right, the question is, should she continue reporting the problems to her employer?
Well, yes, but, you know, quite frankly, if this is a repetitive traumatic injury and it's already been properly documented, then they are trying to pin this problem on some pre-existing condition, that's a huge red flag that basically warns her that they're ultimately going to drag this out long enough to deny it either as a new Workers' Compensation Act case, or deny it just on the basis that they believe even under the old Workers' Compensation Act, that they can prove that her problem is related to a pre-existing condition and not related to the work. This is one of those situations I warned people about before the workers' compensation laws were changed on May 15. Under the new law, she may have no rights to do anything. If this is an old law case, and it sounds like that it is, then she has rights as an aggravation of a pre-existing condition at a minimum, although I'm not sure that this is even an aggravation of a pre-existing condition, because apparently the automobile accident that is the pre-existing condition really is not contributing or causing any of her problems. Nevertheless, whenever you get told by a healthcare provider, you know, look out or look at this prior accident or injury, then that should be a big red flag. She probably ought to sit down with an attorney to sort this out, as opposed to continuing to try to figure it out on her own. I don't know if she necessarily has the need to hire an attorney, but she needs to at least get a consultation with a workers' compensation attorney right away. Okay?